Welcome, welcome everyone. So that's great to have you all joining this session. This for IP Council's webinar will be about the retroactivity of the proposed SEP regulation, a legal analysis. My name is Axel Farazzini, and I'm the Managing Director of IP Council. I will be your host today. So I'm sure you know what 4IP is about. We are a not-for-profit organization, and what we do is we focus on IP related topics. We make the link between IP and innovation. And our mission is very simple. We need to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts in IP organizations, and other stakeholders. On our website, you can find a wide variety of content. Everything is free. There's free materials that has been prepared over the years. We publish studies. We have summaries of relevant papers, recordings of all the webinars, such as this one. We have a podcast that is quite successful that I really I would like to say that you should listen to it. I mean, it's so easy. You will meet great people, experience role models from SMEs, startups. And we have just started with this podcast an AI special. So we also produce easy to digest content, more or less like infographics. That's the corner that we call the 4SME. Where you can find the infographics, the research papers, everything that is tailored for non-IP experts, and the startups, scale-ups, and SMEs. We just have published a new area that is called the IoT and cellular standards made simple. The goal is to make sure that anyone can go through this website and figure out the benefits of standards and IoT across different sectors. That's easy to understand. I mean, all the content is really tailored to make sure that if you have any questions related to IoT and cellular standards, you should be able to find the answers. Now, you might know we have accounts on X, on YouTube, LinkedIn, Instagram. Our handle is 4IP Council. And you can find all the news about IP, resources, anything that we publish, anything that we create, and we try to promote as much as possible from all the companies we are working with, all the academics we are working with. The goal is making sure that you have one place to get all the information about IP. But without further delay, it is my pleasure today to introduce our great speaker for today's webinar, the Professor and Dr. Lee Hencher. And Lee Hencher is a professor of European law at the University of Tilburg and part-time professor responsible for EU energy law and policy at the Florence School of Regulation of the EUI. She is a senior advisor at Becker Botts and skilled in European competition and regulatory law. Over the past 3 decades, she has worked extensively on advising a wide range of clients in regards to European energy law, European state aid law, and European health law. A final remark for the audience, please do not hesitate to use the Q&A tool that is at the bottom of your screen. Should you have any questions to ask to Lee, please put them in the Q&A, and after our presentation, we will take all the questions that we will have received. So, Lee, the floor is yours.
Thank you very much, Axel, for the kind introduction. If you had been listening closely to my CV, you would probably have noted certain words were missing, and those are words such as intellectual property and essential standards. So I'm not a big expert in this area, but I have written quite a bit on the problem of retroactivity, because this is an area we see in other areas of European law, in particular, actually in the energy field. So I am bringing my expertise from that sector into your sector. and offering today an overview of how the proposed delegated act will impact the scope of the SEP regulation, and how certain standards could be included, existing standards, that is. And in particular, I want to explain the role of delegated acts in the European legal order. Now, I will try not to go into lots of very technical legal details, but what I will try to do is explain to you today that although this is a type of legislation, or at least a legal act, that we use a lot in Europe, that is not without controversy. So I will draw on other sectors to illustrate that point. So these are the three sort of basic pillars of my talk today. So there's a great deal at stake by extending the reach of the draft SEP regulation, which I'm sure you're all familiar with the regulation, the draft regulation as such. But what we're really talking about today is whether or not the European Commission will have the power to extend the reach of that regulation to standards which were essential standards which were adopted before the entry into force of the new regulation. So this, of course, means that there are many, many patent families that could be impacted potentially. I've seen figures of roughly 60,000 patent families of standards that have been declared that could be impacted. And if the regulation is extended then to these kinds of standards, they will then fall under many of the procedures that are being set in place for future standards, for new standards. And this is obviously controversial, especially at the moment when we're looking at ways of improving EU innovative leadership, technological leadership. And there are many would contend that in fact this proposal could take us quite a large step backwards and lead to incredibly high losses in this area. Now, that's something we can also discuss perhaps later in the Q&A, but just to kind of set the scene, there is a great deal at stake here. And it's interesting looking back at the process of the formulation and drafting of the draft SEP regulation, that initial draft was accompanied by an impact assessment, as some of you might know. And in that impact assessment, the Commission expressly noted that the various options that it looks at for future standards, there are 5 different options that it considered, it should not extend them to past standards, such as 3G, because it was concluded then in this impact assessment at the time that this would be a very costly exercise because of the large number of patents that would have to be registered, and it could have it could lead to a lot of uncertainty, especially for existing contracts. So it was interesting that at the time then the retroactive effect was actually discarded. And of course, as the draft regulation has taken shape, there are specific concerns that are coming to the fore. And I'm not going to talk about the new regulation in all its detail, but I want to focus on the instrument that the Commission has proposed in the draft regulation, the so-called delegated act, to extend the reach of the Basic Act, so we call the SEP regulation the Basic Act in legal terminology, and the Delegated Act then forms part of that Basic Act. It's a way of extending the scope of that of the Basic Act. Now, delegated legislation is very common in Europe, just as we use decrees and various other executive acts in many legal systems. Delegated acts form kind of similar function at European level. So it's a useful way of updating a regulation, or maybe, you add a new standard, or you take away an area that is no longer really applicable in practice. So in principle, a delegated act is a useful way of keeping Europe's regulatory framework up to date. But there are a lot of issues now coming up around the extensive use of this type of instrument in many areas. And the paper I've written for IP details some of the areas where we have a lot of concerns. I myself see it a lot in the energy space, but you see it also in the AI Act, for example. There's a great deal of controversy in banking legislation about the use of delegated acts to really extend the regulatory burden on industry. And the problem there, of course, is, well, we don't like increased regulatory burdens in any way. But the problem with delegated acts is they're very often extending regulatory frameworks in a way that has not been easily predicted by business. And it's making for a lot of uncertainty in the business environment. So there's quite a lot of general criticism about the use of DAs. And I would add, given the Draghi report and the emphasis on innovation and competitiveness, there is no procedure to scrutinize the impact of a proposed DA on competitiveness. And that is perhaps a major issue to be tackled going forward. The specific concerns when it comes to what we could call the SEP DA, so the Delegated Act to extend this regulation, are, as I've already mentioned, the lack of an impact assessment before this DA was proposed, and then its actual scope extended by the European Parliament last February. On the basis also of very vague tests in Article 1.4 and the recitals of the regulation, where the idea is to include existing standards if there's evidence of significant market distortion and market failure. We just don't know what those terms actually might mean here. So this is one of the causes for concern with the Delegated Act. Now, the additional problem, of course, is that this is a rather unusual way of introducing the retrospective or retroactive application of a regulation. So even if we were to put the application of the existing standards into the basic regulation, this also raises some issues in European law. So it's quite important to consider the legal parameters within which this type of measure, this delegated act, can be adopted. And although that might, as I mentioned, seem quite esoteric, if you're not European lawyers, it's a very important area to be aware of, given the impact, as I've tried to explain, of this measure in your field of business. And what I think we're seeing certainly here with the specific draft delegated act that is being contemplated, obviously we don't have a draft yet, is that we'll have to see what kind of powers the Commission will try to allocate to itself to identify how these existing standards should actually be included. So the drafting of the Delegated Act itself and the way in which the aims of the Basic Act are developed and thrashed out will be very important. So we have to look at some of the potential controls ex ante on that process. And there's also, of course, the very important ex post control once the Delegated Act is adopted. Well, are there ways to challenge that before the European Court? So those are important too. So just basically, to remind everyone, the Treaty on the Functioning of the European Union does introduce this concept of delegated acts. And it says in that article that such acts are allowed to amend technical and non-essential elements of the Basic Act. So that is the delimitation on the scope of such acts. And it's recognized that a delegated act can be useful to expand the Basic Act, but only for technical reasons. It can supplement provisions in the Delegated Act, but again, these must not be, they must not be essential. So that's really important. And we'll see that the Commission is really in the driving seat when it comes to adopting these delegated acts. And that means that, in fact, when we look at the role of the other European institutions, they're very limited. I have explained this in the paper. I won't dwell on it here too much, but basically, in summary, it's very difficult for stakeholders to really challenge the process of the adoption of a delegated act. And that means that the legal limitations then become very important, because if the ex-ante controls are not great, then maybe the only sort of savior could be to go to court. Obviously, not the ideal solution, but even the threat of doing so might be important in this debate. So what is also, I think, important to realize here, if you've never been involved in this area of the law, is that, of course, the Commission should carry out some consultations when preparing the new delegated act. And there are best practices, which we find in a document that's known as the Better Regulation Toolbox. But one of the problems we have here is this is a non-binding list of best practices. So in fact, there's no guarantee that the Commission will follow these practices in detail. It has wide discretion as to how it chooses to conduct processes for feedback and consultation, and it has an even wider discretion when it comes to choosing how to follow some of the recommendations that stakeholders or other parties have been putting forward. And this is also very important because a lot of the new generation delegated acts are very technical, very granular, and that might make the whole consultation process sort of limited in itself to only those parties who are really very familiar with the area. And this is also why it becomes very important to keep in mind that these delegated acts are only meant to change non-essential elements, not essential elements. And that term might be a bit confusing when we're talking about standard essential patents, but this word essential has a different meaning in this context. And essentially what it boils down to, if we look at the court's jurisprudence here, is that it must be left to the legislator to make political and economic choices. So in adopting legislation that will regulate standards, if that process involves political and economic choices, then that choice should be made by the legislature. It should not be delegated to the Commission. And so this is a very essential test. And you might be familiar with these objects here. These are Dyson vacuum cleaners. And if you know anything about these vacuum cleaners, you might know they don't have little sacks, dust sacks. This is one of the great marketing features of the Dyson vacuum cleaner. So you don't have to go out and buy these dust bags and replace them. And of course, the competitors to Dyson weren't very keen when he introduced this innovation. And they tried and succeeded in getting the Commission to adopt delegated legislation that subjected these types of vacuum cleaner to all sorts of tests that Dyson claimed, to put it very simply, were not designed for this type of vacuum cleaner. So the whole efficiency standard that was to be applied in the relevant legislation was only meant to be applied to vacuum cleaners with dust bags, not vacuum cleaners without dust bags. And Dyson succeeded actually in challenging the Commission's Delegated Act on the basis that this addition, this extension of the scope to cover Dyson vacuum cleaners without dust bags was an essential addition, and that was therefore not allowed. The Basic Act, this was a consumer safety measure, was being supplemented by adding an essential element. And so that decision, or that delegated act of the Commission, was struck down by the European courts. So that was quite a victory to Dyson. But this case, I think, is very useful because it explains this concept is very important. And in theory, in legal theory, of the Commission should not extend the scope of the Basic Act, so the SEP regulation, through delegated acts to cover essential elements. And I think we can argue that to cover existing standards could well mean that we are crossing that line and looking at changing the scope of the basic legislation. Now, the retrospective application, or the retroactive application of the directive of the regulation, I should say, is also very problematic. It's problematic, as I mentioned at the beginning, because generally we're supposed to avoid retroactive application of new legislation. Obviously, we have to adopt legislation to regulate future issues, but to adopt a draft regulation that will have a retrospective, a retroactive application is always problematic, especially retroactive application, because there you're taking away rights that have already been established in the past, and you can be seriously undermining the economic position of those that have acquired those rights. And this is obviously what could happen if existing standards are brought within the scope of the SEP regulation. So there are guardrails here in European law that are important to recall. Firstly, we have general principles in European law that we should respect legitimate expectations. So when you have made a deal, let's say in 2020, you don't anticipate new legislation coming into force in 2026, and you don't anticipate new legislation coming into force in 2026 that will have a retroactive impact for an unlimited duration on the area in which you are active. So your legitimate expectations when you sign up when you sign contracts, or you admit to standards that you thought were governed by a particular regime should be respected. However, of course, at the same time, the courts recognize that lawmakers must have a margin to adapt circumstances. And so there are ways of trying to deal with transitional periods for existing contracts, or for the rights of existing players in the market. And we do see that in other fields. In the energy sector, which I'm very familiar with, we see that a lot. So we see various provisions in regulation to grandfather existing rights, existing contracts, or other kinds of transitional arrangements can be introduced to protect parties who have made certain arrangements prior to the entry into force of these new rules. so that this retroactive impact is at least limited for a transitional period. However, as I say, I'm more of an expert in energy law and in the energy sector, and it might be not so easy, I understand, to find ways of introducing a fair transitional period in your sector. And that will be something of a challenge. And it might well be that if it's not possible to do that, that would at least lead the courts to conclude that these legitimate expectations cannot be properly respected. So I think that leads me to my final conclusion here. I think there are three areas of concern to be aware of. And these are the areas of concern that I would flag up as a non-expert in IP, but as a European lawyer, familiar with the institutional workings of the union and familiar with how some of these issues have arisen in other sectors of the European economy. So these are there's a lot of political unrest, as I've tried to explain, political concerns about how these DAs are being adopted. It's not a transparent procedure. There's too many aspects left to very heavy lobbying, which causes some to comment that this is not the right way to deal with very important changes to the legislative framework. And there are obviously a lot of legal concerns, which I've tried to mention here, trying to explain as to the scope of a delegated act. There are, in fact, in the energy sector, there are challenges in the European courts going forward at the moment as to the way the Commission has tried to use DAs, the instrument of the Delegated Act, to, if you like, kick down the road various controversial questions. They don't want to put them in legislation, but they try to kind of smuggle them in through a delegated act. And I think finally, and probably most importantly, maybe I'm not the one qualified to talk on that, but this is probably something you're more aware in your sector, that there are tremendous economic concerns as to the impact of the proposed DA on existing standards and on the revenues that leading companies can enjoy in this area. So thank you very much for your attention, and I turn the floor back to Axel.
Thank you so much, Lee, for this explanation. I mean, many people believe that they understand what delegated acts are about, but it is much more complicated than what it looks like. If we start with the first question that we have received, this is about the scope. I mean, do you think that would be possible? That even though this regulation is about essential patents, maybe for the telecom sector, do you think that it could be possible that it will be broadened to other sectors through delegated act?
I think that sounds like a very important question. But I think that's just the problem of the Article 1.4 of the draft regulation and the recitals. It leaves it very open. It doesn't seem to impose any parameters, any tests to decide how to expand the tests. To expand the regulation to include existing standards. It only says that it will have to be shown that there has been some risks of market failure and significant distortions of competition. So it doesn't really provide us with much guidance as to what could be covered. So it could be anything of relevance, I think. But maybe, Axel, you have a practical view on that.
No, that's very interesting because, yes, indeed, the uncertainty that it creates can worry many, many different industries. But another question is, are delegated acts used frequently to supplement or expand EU legislation?
Yes, indeed, they are. As I very briefly explained, obviously most governments in most countries use decrees or secondary legislation, it's sometimes called, or non-legislative acts to update legislation because it's quicker and simpler. So it's a normal practice, but it's supposed to be, according to the EU's, if you like, constitution, the treaty, there are these guardrails, there are these limitations that you're not meant to use them to expand into these essential elements. We have a register, the Commission keeps a register of delegated acts, and I think if I looked recently, there were about 2,400 delegated acts adopted every year. So it's a widely used instrument.
Okay. But then the follow-up question is, what are the main problems as you see it with the rising reliance on delegated acts?
Well, I think, and that's something I try also to explain in the paper, and what I see from my experience in the energy sector is, well, first of all, with the ex-ante controls, it's very difficult for stakeholders to follow what is going on. The Commission will publish a draft on its website, and you will get a very short period to react. Usually 4 weeks, that's standard. Commission could extend it, but it's usually 4 weeks. So if you miss it, if it's the holidays or whatever, or you don't have sufficient, resources to keep monitoring Commission websites, you might find yourself with a very limited period to react to the draft. That's the first problem. The second problem is that these drafts can be extremely technical, so that you might not have people available to actually understand exactly what consequences could be implied by these complex instruments. It might take quite a detailed analysis to actually realize, the full consequences of what's being proposed. They're very granular, increasingly granular. And then the other problem is, so the Commission runs this procedure for feedback, but it's up to the Commission to decide what to do with that feedback. If the Commission doesn't like feedback, it can just ignore it, basically, but or it can pick and choose what feedback it likes. Normally, when it drafts the DA, there will be some questions that they will put into the consultation where they might want feedback on. They don't have to do that, but they might. So they might try to guide the process. And the final version of the DA, when it's adopted, should give some kind of summary as to the reasoning behind its adoption. And there, the Commission might draw on not specific comments, obviously, but concerns that it has received during the feedback process. But the problem here is that, as I say, the Commission has a lot of discretion as to how it conducts this process. Now, I believe that the Commission has launched some kind of expert analysis of the potential scope of the DA, if I'm not mistaken. That in August of this year, they did announce some kind of expert group that would look into some of the issues around extending the scope of the draft SEP regulation. But that process has only recently been launched, so we don't know what conclusions might come out of that and how that might eventually feed into some kind of consultation period.
Very interesting. And one question is related to, in your presentation, you refer to recommendations or best practices for the DAs. And the question is, can you can you please explain what those recommendations or practices are about?
Yeah, okay, thank you. That's a good question. So this is about the way the DAs are drafted and adopted, and so this better regulation toolbox has been developed to guarantee that stakeholders should get more access to the process. That's one part of it. And also actually to give members of the Parliament, European Parliament, also better access to the adoption process. One thing I didn't have time to explain in any detail here is that a delegated act it's really in the hands of the Commission. And the Parliament and the Council can only veto what the Commission is proposing. So they can't amend it. It's a kind of yes or no. And the Parliament can only say no if it votes on with the majority of all its members to throw out the delegated act. And that's actually very difficult to achieve in practice, even if the measure is really controversial, because not the Parliament rarely seems to sit in plenary with all its members present. So to get that majority is really difficult, and it's actually only happened once. So when you think that there are 2,000 something DAs being adopted every year, over 15 years we've had these DAs, it just shows you that you can't rely on the Parliament to throw them out.
Okay, that's very interesting. So I know that you are not an expert in standardization, but one question that we received is standards are very often building on the previous standard. One example is when 4G was published, a few years later, 4G, an advanced version of 4G was then published. And then they like, it's not like a different standard, but it is still different because that's a new specification, that's a new version that relies on something that has been already published. If we take the example of 5G, for example, it has been already published, but we can expect that in the next few years, a sort of 5G advanced specification might be published. How that it will work actually? Because then if it is not retroactive and it applies only to future standards, but those future standards are actually relying on past standards, will it require delegated acts or what? I mean, what certainty that will create an uncertainty?
Thank you. I think that's a question also many people have been scratching their head about in this discussion, if I understand rightly, indeed, that you don't just jump from 4G to 5G to eventually 6G. This is a process where you're using standards and varying them. So one of the problem with the current idea that you would have a DA, as it were, focused on certain existing standards doesn't really make, I believe, much sense, because it's like just pulling out a bit of a ball of wool. You could try to regulate some patent families or some standards, but because of their interrelation with others, I think, Axel, you told me once that if you look at the dashboard of an EV, how many standards are in there? In an electrical vehicle, it would be many thousands we would be looking at just when we drive a current model of a Tesla or whatever. And so if you were to start saying, well, that standard would have to be retroactively reassessed, you would then have to consider, what that meant for all the related standards in that vehicle. You can't just isolate one standard, if I understood correctly. So this is going to be a big challenge. And one of the potential issues for drafting the delegated act will be how to create a process where you could have maybe kind of ring fence those existing standards that you have some evidence are problematic, and how you would stop that kind of cascade effect onto other related standards. I think that that will be a big challenge going forward, to indeed deal with this legal uncertainty that the question raises. I hope that answers the question. That's how I
Yeah,
understand it.
it answers definitely the question. I think, you clearly identified some parts that are that there is a lot of unknown. And
Mhm,
when you refer to the Council and the European Parliament having very limited powers to veto the delegated acts,
mhm.
um, how would you characterize the importance of the judicial scrutiny? How can it be improved, or what's your opinion about this?
Well, I think it's because it's very unlikely, unless there is sufficient, I think, mobilization. You can't just rely on the Council and the European Parliament's power of vetoes to stop these acts being adopted. Obviously, there will be political pressure, but for the Parliament, especially, to use its veto is very difficult. For the Council, of course, it will be on the basis of qualified majority. But the trouble with the way that system works is, of course, there are always trade-offs being made. You know, the Council, some member states might accept something because they will be guaranteed that their interests will be met on other issues. So that's why judicial control becomes very important. So if you think that the delegated act, once it's adopted, does go beyond this test, that it is changing not just technical elements, but also essential elements, then just like Dyson, you have to go to court and thrash that out. It's a bit of a long process, but I think if especially the council, is aware that there could be challenges and that the legal basis is not sound, then they might be more reluctant to actually accept the measure. And of course, the draft SEP regulation is a draft. I mean, it's the Parliament that has amended the Commission's draft and extended the possible reach of the regulation, the potential regulation. So just, I think, explaining clearly what the judicial limitations are, the legal limitations are on the powers to adopt delegated acts is already very important at this stage.
Very interesting. Um, I think the example of Dyson raised several questions. One is, how long did it take
Uh,
to
That's a very good question. Um, Maybe that was also the reason Mr. Dyson, he was very keen on Brexit. He started, I think, well, he started informal challenges and lobbying and many years ago. And I think it took him well, he first lost at the court of first instance, as it was then called, the General Court. They thought the Commission had a lot of discretion in the way it could adopt these measures, and he had victory in 2017. So it took him about 6 years to battle through. Yeah, yeah,
Wow, 6 years. Okay. So
yeah. And then
clearly
he tried to also, more recently, he tried to claim damages against the European institutions to cover all his costs.
okay, very interesting. And you referred to um, that the commission appoint individuals to the expert group.
Hmm.
And how does it work? How do
Yeah,
they
yeah,
pick
okay,
the experts?
yeah. That's that's also a very good question. So delegated acts, they're actually drafted by the Commission, working together with experts. Now, these experts could be picked according to the subject area. And they could be picked by the Commission and the member states. But normally what happens is that you have a kind of a standard list of experts that the member states have nominated for, other areas that the Commission deals with. I mean, they're experts in patenting, whatever, but they're also advising the Commission on what we call implementing acts and other types of acts. So the Commission doesn't set up a completely new expert group to deal with this particular delegated act. So experts are usually national experts, and they are suggested, their names are put forward by the member states, and the Commission keeps also actually a register of these experts. But so they're kind of from at national level. And this is then the way that, if you like, the member states themselves exercise some scrutiny and surveillance ex ante over the process by putting their experts there. But they won't necessarily be looking at the broader legal picture. They'll be experts maybe on patenting or on telecoms. I would have to check exactly who they would put in the process here, but they would not necessarily be legal experts.
So do you mean that, for example, if the experts of the specific group decides that one standard may indeed raise some issues and will need to be included under the draft SEP regulation, then a delegated act should be created to cover it.
No,
They are not expert in the technical domain at all.
no, they are. It's the experts are appointed by the Commission to help draft the delegated act.
Okay.
So in the basic regulation, the basic SEP regulation, the one that's been amended by the Parliament and now going back to the Council, it has an Article 65. I think it's little c now, which explains that this delegated act will be adopted according to a certain procedure. And this is the procedure where the Commission then the standard procedure for adopting a delegated act is that the Commission does that with this expert group.
Okay, so
they
this expert group is not in charge of doing the assessment regarding the standards to include in the delegated act.
Well, they could be. It depends on how detailed the delegated act is. So you could have a delegated act that lists the standards, and they could indeed list what's going to go into the delegated act, or they could alternatively try to expand on these tests. So the tests of significant distortion to the market, they might try to elaborate that test.
Okay, so if they elaborate the test
Yeah.
to prove that there is a market
Yes, how are
distortion.
we going to do that? How are we going to do that? But it's
Okay.
not clear to me whether it will be whether the delegated act will list standards. I think it could do. It's possible legally. I mean, the basic regulation seems to provide that the delegated act could draw up an annex with standards that will be covered, and that annex could also be amended quite regularly. But the procedure for amending it, I mean, let's say, for the sake of simplicity, the first version of the Delegated Act has an annex with a list of standards from the 5G era, right? And then there's a procedure included in the Delegated Act to update that annex to maybe even include older standards, 4G, for example, because they find that you need to expand the scope. So that would be how it could work.
Okay, very interesting. And do you have the feeling that this question is more like if the regulation was without delegated act, do you have the feeling that the delegated act is actually
Yeah,
exacerbating
yeah,
the problem at the
yeah.
end?
Well, I think there are two problems. So the problem of course, the scope, whether you can include essential elements or not, that goes away if there's no delegated act. So the legislation, if the legislation says this is going to retroactively impact and makes a list of what the legislator has decided has to be included in the act, then of course we've solved that problem, because we say that would be a problem if it goes down a level to the delegated act. But the problem of the retroactivity is not resolved. So the question, the basic question is, okay, we have a new version of the regulation, and that regulation has a new article in it, let's say, for the sake of argument, Article 20, which says this act will apply and make a list of standards that are, existing standards. That's where the retroactivity would come in. And what I think, looking at similar exercises in especially energy, but there are other areas, that's where you would certainly need a transitional period, or some kind of grandfathering arrangements or some procedures to guarantee the legitimate expectations of those who've already published their patents, published their standards, and gone through all the procedures that have been perfectly legitimate until now, or until this new act or regulation is adopted. So retroactivity remains a problem, and we still have to find, I think, a solution to meeting the legitimate concerns that retroactive legislation should not damage the legitimate expectations or violate the legitimate expectations of those who have already organized contracts or the access to standards on the assumption that what they were doing was perfectly legal.
Very interesting. And I think that might be the last question for today. One one question is more like related to one of the first ones that we received, which is about the industry and to what it could apply. Is that really possible, in your opinion, that the way the regulation is drafted could expand through a delegated act to, like, I don't know, pharma or construction or safety? Is that something that sounds to be really possible? That's credible?
I think anywhere where where there's a SEP, right? Where there's a SEP procedure, yes. I think it's possible.
Okay. And if we miss the 4 weeks open review of the proposal, then we have to go through the Dyson way.
Yes, you have to get your vacuum cleaners ready to sweep up the offending legislation. Yeah.
Okay. Okay. And maybe finally, one question is, so do you see a solution? Do you have a solution to propose or a potential solution?
I thought the easiest solution would be just to make it life simple and only introduce, if you're going to introduce the regulation, the new regulation for the future. That's obviously the most simple. I mean, in terms of this current debate, whether or not it's a good thing to introduce that legislation is another debate. But in terms of resolving the problems we're talking today, the best thing would be to go back to the Commission's initial impact assessment, which was it's too complicated to retroactively cover existing standards. The Commission had already come to that conclusion in, was it 2020 when it first drafted this regulation? So,
No, very good.
yeah.
Very good. So let's see how things will unfold in the future. And thank you very much for clarification. I think that we are getting closer to the end of this webinar. We might have not been able to take all the questions, but I can assure you the paper is forthcoming. That should be published in the next few weeks, maybe even next week. I think that's really the final steps to finalize it. This was a fascinating topic, and I'm sure that even non-lawyers will have appreciated all the details that you have provided. I would like to remind to everybody on the webinar today that you can register to the next webinar that you can see on the slide, which is on a very specific topic, because that will be about leveraging geographical indications, benefits, types, and the registration essentials. So this is something that is coming up on the 5th of December. So please feel free to scan the QR code or to go directly on the 4IP Council website. Then, for all of you who have attended today's call, you will receive a short survey tomorrow, I believe. If you can just use the survey to provide your feedback regarding this webinar and maybe potential topics that we should cover, that will be highly appreciated. And as a conclusion, I would like to thank you again, Lee, for everything that you have shared with us today. I'm looking forward for reading the final paper in the coming days or weeks. And in the meantime, I wish you all a great end of the day.